Okay, Chapter 4, Video 4. And we're talking about the Miller test that's applied with regard to what's called obscene speech. And of course, one of the problems that the Supreme Court has had is deciding what is actually obscene. You may recall hearing that Justice Potter Stewart, who was on the Supreme Court bench for many years, wrote the famous line that said, in terms of struggling with defining what's obscene, he said, "I know it when I see it." Of course, that's not a very good legal standard. It doesn't give you and I any idea of what's legal or not legal, but it illustrates the difficulty that the court has had in defining what is obscene and therefore illegal and what is not obscene and illegal. Now, this third prong, created a lot of different problems, and so did number one. So let's start with number one. The problem that was created with number one was this phrase, community standards. And so the question became, well, what community? Because obviously what's obscene in rural South is probably not obscene in metropolitan New York in many instances. So that created a problem, and the court had to more clearly define that. And I think now it's more of a national standard. Number three, as a whole, lacks serious literary. The original one didn't really say as a whole. It said lacks serious literary, artistic, political, or scientific value. As a result of that, when the test was first applied, people who were purveying material that might be obscene would put something in the middle of it, like in a magazine that would have like famous poetry in it. So then they would argue that it had literary value. So they had to expand it to say, no, you can't just slide something in there and get away with a lot of really gross, obscene stuff just because you put something in there that has some literary or scientific value. You have to look at the document or the item as a whole. Okay, so freedom of speech. Even speech is subject to reasonable restrictions. There's a balance between the government's obligation to protect speech and protect and a citizen's right to exercise. So usually the government has greater ability to restrict what we call time, place, and manner of speech versus content. And a classic example of that is where you have a situation like, for example, the Nazis, American Nazi Party or whatever they are, wanting to have a get-together or a march, a parade, okay? It would be illegal to deny them the right to parade and have their swastikas and whatever else they want to have under the First Amendment. However, the government could regulate when they could do that, and the manner in which they can do that, and the place in which they can do that. Okay, based upon government, reasonable government interests. So laws that restrict the speech have to pass a compelling government interest test. Corporate political speech is another interesting area. Remember, I said earlier that with regard to the first 10 amendments, they apply to artificial persons to some extent. So the question is, how do they apply in speech? And of course, the famous case now, Citizens United versus Federal Election Commission. This was a situation where there was a federal law that regulated the amount of money that can be contributed by corporations to specific PACs and campaigns. And the Supreme Court ruled, first of all, that the contribution of money to a political campaign is a form of expression, a form of communication, a form of speech. Second of all, they said that it was protected, and so therefore that statute was unconstitutional. This has been a highly criticized finding by the Supreme Court, and a lot of people do not like this law and this ruling and would prefer to have laws that would more restrict the power of corporations to donate particularly large sums of money to candidates. Okay, we talked about commercial speech. Okay, fighting words are not protected speech. Defamatory language is not protected speech, etc. Okay. An interesting area was the PROTECT Act in 2003, making it a crime to intentionally distribute virtual pornography of children without indicating that it is computer generated. Okay. Okay, religion. So with religion, there are two parts to the First Amendment with regard to religion. The Establishment Clause and the Free Exercise Clause. So the Establishment Clause basically says that the government cannot establish a religion or do anything that is in the form of establishing a religion. In other words, have a government religion that is favored. The other is that the government cannot prevent us as individuals from expressing or practicing our own religion, exercising our right to do religious things. Of course, all these have limitations, as we've talked about before. Okay. With regard to free exercise, the courts have interpreted that as including the right of individuals at work to be able to reasonably exercise their religion, and for employers to reasonably accommodate that. However, the government can act in protecting the public when religious practices work against public policy and the welfare of the public. Okay, so we'll stop there with part 4. Again, the magic word for chapter 4 is Constitution, and we'll pick up with part 5.